Hi, welcome to the Legal Connection Show. I'm Tony Collins, and you're listening to IR Lone Star Radio. Our show broadcast on Tuesdays at noon for an hour, and we're on FM 104.5 and FM 106.1 if you're driving down the road and want to listen to us on the radio. You can also catch our podcast on the irlonestar.com internet site, or you can go to our Facebook page. And if you miss our whole show, you can go back and also watch it on YouTube by just Googling the Legal Connection Show. Today, we're going to have a fun show. It's going to be a game show, and I'm here with my stepdaughter, Courtney Collins, and she's going to tell us a little bit about herself in a second. But what we're going to cover today is frequently asked questions in a game show format on DWIs, on gun laws, and on just general criminal procedure. And Courtney's going to let me know, or let the listeners know just how little I know about the law, because she's going to ask me questions, and I do not know the answers right off. I don't know what questions she's going to ask me. So, Courtney, welcome to the show.
Hello.
And tell us a little bit about yourself.
I am 25 years old. I graduated from Texas A&M University in 2018, and I currently am searching for a job.
What is your degree in?
Nutrition.
And what kind of job are you looking for?
To be determined.
No. What if you had your dream job, and someone said, and your fairy godmother of jobs came and tapped you with her little scepter? And you said, and you had the interview right after this today, and you could dress any way you wanted, and you would get it. What would that job be?
I would be a vet.
Okay, so you want to go to veterinary school then?
Yes, I love animals.
Okay, so you need to go that direction then, right?
Yes.
All right, so the fairy godmother says get your veterinary license. And don't you have a friend that's a veterinarian?
In school currently in Colorado.
Oh, okay. There was a girl you went to high school with that worked at the animal clinic.
Oh, Alyssa?
Alyssa, and then there was another one. You'd known her since you were like 10 years old, and she has really big eyes, and I remember she had really big blue eyes. She was with us when we went to the Johnny Rockets that night. Well, name some girls that were there, and the name will come to me.
Oh, my gosh. Laura Dobrinsky.
It might have been Laura Dobrinsky. It was.
She is now married and I believe has one child.
Okay, she does. She's not a vet?
No.
I thought that she wanted to be a vet.
She went in different direction.
Wow, who knew? Okay. Well, that is good to know. You're going to be a veterinarian, and I'm sure your animals are going to be happy about that too. And all right, so you're going to hit me with a bunch of questions that I may or may not know the answers to, because I don't know what they are. But we've got frequently asked game show questions that our listeners can also try to guess too. So ask me some questions.
Is drinking and driving a crime in Texas?
Drinking and driving is not a crime in Texas, but drinking, if you are intoxicated, is a crime. So let me sort of put some parameters around that, and you can tell me how correct I get on this answer. If you if your blood alcohol is above a 0.08, and you won't know that, but if you had your own little breath tester, because let's say you drink, and you drive, then you would know that if you had one that was calibrated, or maybe the little handheld ones. It's usually about 2 drinks, and it depends on how much you've eaten during the day and how big you are and how much alcohol was in the drink, how you metabolize. But usually, without me getting into a lot of detail about how you get to the 0.08, if your blood alcohol is above 0.08, and it can be proven that you had that alcohol level when you were driving on a public thoroughfare in the state of Texas, then that would be illegal. And if you don't have alcohol in your system, but you have some drug or something that makes it so that you do not have your physical or mental faculties of a normal person, and maybe you're just like that naturally, then and a jury believes that, then that would also be against the law to drive. And if you're a teenager, I believe there's that if you're over 18, and you have, or even I think it's over 16, and you have any alcohol in your system at all because it's zero tolerance for minors, so it's between 16 and 18, then that's illegal. You can't drink it all under the age of 18. See, I get confused about that between 18 and 21. That's a whole different set of laws, but I do not believe that it's the alcohol laws. So how close did I get to the right answer?
So it tied into the second question as well. What is the legal drinking limit for drivers in Texas?
Okay.
And it talks about...
So what are my answers then? Because I have no idea.
The first question, it is not a crime to drink and drive in Texas. However, you may not legally drive if your blood alcohol content has exceeded the maximum percentage allowed under Texas law, or if your ability to drive safely is impaired by alcohol, drugs, or both.
Okay. There you
go. Second
I got close.
Yeah, no, that was like you went right into the second question, which was the answer to a legal drinking limit. Is the blood alcohol limit in Texas is 0.08 BAC unless you are under the age of 21. If you are under the age of 21 and your BAC is 0.2 or higher, so, 0.02
right.
or higher, big difference, then you are legally intoxicated.
Oh,
Additionally,
wow. Okay.
the legal limit for commercial drivers is a BAC of 0.04 or more.
That's interesting. So it's not a zero tolerance. You're saying it's a
didn't know
0.02 if you're 18 to 21 or 16 to 21? What did it say?
It doesn't specify.
It does say under 21.
It just says under the age of 21.
Well, I will tell you this. I had a client who was a minor who had a DWI, and they said zero tolerance. So that's a good thing to know to argue. But that was a few years ago, so maybe the law has changed.
Is like a temporary order set in place, maybe? Like for the zero
Well, it won't be
tolerance?
if you're already in trouble and you've already been arrested for DWI. You can't drink at all. Your bond is not going to let you touch alcohol at all. And if you get a pretrial intervention because you have met all the criteria to be able to, let's say you're drinking, you're just as drunk as can be, and you qualify for these pretrial interventions that they offer in Montgomery County or Harris County or the different counties, and you can usually only if it's your first offense and various other things. But if you qualify for it, you can't drink at all. Part of your conditions are for that full year that they're giving you a break because you were just as drunk as all get out, and you were never going to be able to get a not guilty in front of a jury by any stretch of the imagination. Then they give you all these rules for 1 year where you have to go in and do blood alcohol test. You have to, for at least 6 months, you have to have the breathalyzer in your car or a what's called I think they call it a scram, but really it's a portable in your house if you don't have a car. They are really, really strict with you because you have to prove yourself for that year. Then they dismiss it, and that's a wonderful thing because if you can get that dismissal under a pretrial intervention because you made one mistake, then you can get that expunged from your record, and it doesn't even show that you've ever had a DWI to count toward the next one unless you get a DWI in the same county after and you got the expunction because the county won't allow you to expunge it for that county. So it's kind of a little an esoteric sort of peculiar thing with the expunctions. But that went too far in answering your question.
No.
All right,
Good
so
place to know.
what's your next question for me?
What are the penalties for a DWI in Texas?
I'm
for
gonna
the
get
first
these-
offense.
I'm going to get these totally wrong because I never can remember because I usually get my cases dismissed for my clients. But the first offense is a Class B misdemeanor. That's one step above a Class C, which is the ones where you don't get arrested. Class C's are your lowest level offense. They were like traffic tickets. The only Class C misdemeanor that I'm aware of that you can get arrested on is a public intoxication, and you'll get arrested on that if you don't have somebody with you that can take you to a safe place. But a Class B misdemeanor is the next level up. It's the next lowest to the bottom of all crimes. And so they're not even really considering a DWI a really high-level crime, but it still has penalties, including jail time. And if I remember correctly, a Class B is going to be a $2,000 fine or less, 180 days in jail or less, and court cost, and you can only get a Class B if you're under a .015. Otherwise, it bumps to a Class A on your first DWI. All right, how close did I get?
So that was... Everything you said was accurate.
Yay.
Punishable as a fine not to exceed $2,000. Jail time, 72 hours to 180 days. Driver's license suspension,
I forgot that.
90 days to 1 year. And the court may probate the jail sentence and waive the driver's license suspension on the first offense only. And possession of an open container of an alcoholic beverage increases the minimum term of confinement by 3 to 6 days for the first offense.
Okay.
3 days to 6 days.
What they normally do if you have an open container, that means you have an open container of any kind of alcohol in your car. It will bump that to a Class A, or it's a separate charge. And I forget because they always use that as a negotiating tool. But the container can have a drop of alcohol in it. It doesn't have to have anything in it. If it's got the residue of alcohol in a cup, that's an open container. So if you've been drinking out with your friends and you're not even intoxicated, having an open container in your car, even if you're not the driver, is against the law. So you want to toss those open containers before you go so it's not in your car. Okay, next question.
Now the second DWI offense.
What are the penalties on that? They bump a little bit because you're now in a new section of the law. You're now a Class A misdemeanor. And with the DWI Class A, you're facing a $4,000 fine or less and up to a year in jail. You have a mandatory 3 days incarceration that has to be served in jail. If you have the open container, I think that doubles to 6. And, of course, you're going to have a longer license suspension. I forgot that last time. And I'm going to add in there that it's a Class A. I said this before. If your blood alcohol, even on the first offense, is over a 0.15, it goes up to a higher offense, even if it's your first DWI. If there's a child passenger in your car, it goes up to a felony, or if there was a wreck involved. And in your second offense, just was thinking something else about that. Oh, you can get your second DWI offense reduced to a first DWI as far as punishment if the prosecutors will agree to that. But it will still show for that's only for punishment. It'll still show for counting the number of DWIs you have a conviction for in your record, because it'll always show up for law enforcement. Okay, how close did I get?
That was all correct, and then some. I was like, I'll just be repeating.
Okay, well, repeat it.
Punishable by a fine not to exceed $4,000. Jail time is 30 days to 1 year, and your driver's license is suspended for 180 days up to 2 years.
Okay, and I'm going to add that when you get your driver's license suspended, I mean, that is like, the end all for some people. It's like, what am I going to do? And that people want to cheat. And oh, sorry, my phone is going off. And so people want to cheat and just drive without their license because they've got to use their car to get places. And it's like that's their livelihood. They have to have a car. And so you don't need to do that though. You can get, if you have a license to begin with, a lot of people are driving without a license when they're stopped. If you're stopped and you have a driver's license, the very first thing you want to do, even before you call an attorney, is you want to, because you're not making any admissions here when you do this, you want to call the DPS. There's a phone number at the bottom of the paperwork that the officer will give you when you're arrested. Just because you're arrested does not mean you're guilty, because you may not have been driving while intoxicated. But the paperwork they give you, it's called the DIC 23, 24, and 25. At the bottom of that paper, there's a phone number that you need to call. It's the DPS. You're going to ask whether you make a phone call, you text them, you fax them. Believe it or not, there's still faxes. You send it in the mail or you email them. I like email the best because you have a record of it and it's the easiest. You call the DPS and you ask that they set you an ALR hearing, and that is a license. what does the A stand for? Administrative License Revocation Hearing. And what that call does is it prevents your license from being suspended until you have that hearing. All right? And that's very, very important, because if you don't make that call 40 days after your arrest or the stop, and if, most of the time it's an arrest, at that point, they wouldn't be taking your license, then your license is suspended at that point. And then you've got to pay a fine up to $1,000 to the DPS to get your license back, and various other things. But if you ask for that hearing, you get to go before a civil administrative judge, usually by Zoom these days, and explain to them why you are not driving while intoxicated and how the state cannot prove their case. It doesn't cost you anything if you don't have an attorney. If you have an attorney, you don't have to show up for it. They'll argue it for you. But it's very, very important, because if you can get that, for a lot of reasons that you can win these, and even though they're difficult, it's a lower burden. If you can win that, it helps your criminal case. And it also keeps your license in place. It may prevent you from having to pay penalties at DPS. Now, even if you don't win that administrative licensing hearing, or if you forget to call, or let's say you didn't have a license at all because you're not here legally, which of course you are, but I'm just going to use your example of let's say you came from Mexico, you needed to drive, you needed a Social Security card these days to get a driver's license. You can't get one without it. And if not, you don't have the Social Security, you've got to have your birth certificate and various other IDs showing that you're a citizen. And they're very, very particular about getting the certified copies at the DPS. You can still, if you have a license and it was suspended, well, let me go back. You can't even get an occupational license if you never had a license to begin with. But if you did have a license, then you can get an occupational license. It's not difficult. You can get it from either the court where your case is set, the misdemeanor court, but it's even cheaper if you go to the Justice of the Peace Court. It's paperwork filed online. You just fill out the criteria that you need. It only costs $80 to file it. The judges are really, really nice. A lot of people do it on their own. It's like a fill-in-the-blank form. And then you will have your occupational license for up to 2 years until you get your license back. No need to cheat and try to avoid the police. You'll have an occupational license. The only thing you've got to do is if you have a breathalyzer in your car, an intoxilizer, like a lot of times you have to have anyway because your license has been suspended and you forgot to call, you don't have to keep a log. But if you don't have that and you beat the system, so to speak, in every other way, then you have to keep a log of where you've gone. That's the only thing, the only other thing that's extra without having just a real license. So that's important to know for your for all DWIs, is to make sure within 2 weeks of the arrest that you make this call to the DPS to keep your license alive and active. And if you miss it, don't fret. You can get an occupational license so you don't have to break the law. All right.
There are ways.
Yes, there are ways.
All right. The penalties for the third DWI offense.
It escalates considerably by the third DWI, because now the society and the court system believes that you are never going to learn your lesson and you're endangering people out on the road. Even if you're just trying to get home from a restaurant, you're trying to get home from that party because your parents are mad if you're a teenager because you got the car. They are, for any number of reasons, you're trying to get back from your mistress's house back to your wife so that she doesn't know you've been out. Whatever the case may be, that third DWI, there's got to be some circumstance that has made you get behind the wheel because you've already been through the court system twice and it's cost you a fortune. So the third DWI escalates to a felony. It's a state jail felony. It's serious. I could be wrong about which felony it is, but I believe it's a state jail, and it's up to 2 years in state jail prison. The difference between that and county confinement is county you can get 2 to 3 to 1 days. So if they sentence you to 90 days, you would be out in a month or a month and a half. It's 2 to 3 for 1. In state jail, it's day for day. So whatever your sentence is, you are day for day. The judges will usually also make you do a program that's in-house. And they'll wait for you to get a bed, so to speak, because it's in-house. And they'll make you go through an alcohol program, like a detox. If it's not alcohol, it could be drugs. You have a lot more penalties, and it may not have it on this, but I've seen this what happened. They actually have DWI designation courts in all the counties. I think they may be called STAR courts. They may actually be called DWI courts in Harris County because there's so many people there that they've made it more specific. But there are courts that help you with your alcohol problem. They'll probably make you go to AA. They'll make you do more things. But the actual penalty under the law is going to be up to 2 years in state jail, prison, if it's not the higher one, which is up to 2 years in actual prison. State jail is in Atascocita in our area, and it's a little bit nicer than the actual state prison system, the TDC. I think the fine, I think it might be up to $5,000, but I can't remember. What is the third penalty?
It is punishable by a fine not to exceed $10,000.
$10,000. Okay,
Yeah,
it's a lot more.
hefty.
And what is the prison?
The imprisonment in state penitentiary
State jail. Okay.
is 2 to 10 years.
2 to 10. Then that's not state jail. Wipe
So-
out what I just said. It's not a state jail felony. It's a third degree felony, which is the lowest level felony. And that means that you're facing between 2 years at a minimum if you go to a jury in the prison system, TDC, Texas Department of Criminal Justice, and up to 10 years. Usually on the third, they will probate that for you'll get a probation for, 'cause they don't want to send you to prison if they don't have to, and they think it's just a mistake. They will give you extensive. They will watch you extensively. They'll give you a lot more going to your probation officer. If you're on probation, they will have a fine with it generally, unless you can show that you're indigent and you've been trying, or there's other extenuating circumstances. But 2 to 10, and if it's your third plus, fourth, fifth, sixth, you will face up to 10 because they start getting really, really strict with you after the fourth DWI. And you don't, that's why you always want to have your attorney try to negotiate a probation. If you say, no, I want to fight this and I'm going to a jury, the judge can't accept a plea bargain with the prosecutor by the time you are no longer negotiating with the prosecutor. These are mandatory state rules. The judge has to follow these guidelines. So you're going to get a minimum of 2 years in prison, and it won't be probated, I don't believe. Or the judge might have the option for probation, but 2 to 10, and that's 2 to 10, whether it's probated or not. That's what you're stuck with on the third. All right. So what's the next one?
Next penalties for having a DWI with child passenger under 15.
I just watched a trial on that. It was very interesting because it was a trial where the defendant was driving with his 5-year-old child down FM 1960. It was in Harris. He was going toward Kingwood or Humble, and he ran into and over a person riding a bike at 11 at night. He didn't stop, probably because he was intoxicated, and the person was killed. And the car behind him, apparently, as the police assert, ran over the victim again, and he was dragged. Whether he was dragged by the first car or the second car, this 49-year-old Conroe citizen, his name was Chadwick Sangster, because I watched the trial, and then I watched his daughter, talk, his I guess, dependents, which wasn't dependent anymore, his children, the children of the guy that died, came and made statements about what a great guy he was and how they were so upset by this. And ultimately, they didn't charge him with intoxication manslaughter because they couldn't prove he was driving. They found the truck about an hour later by just a citizen saying they had found it at a convenience store. And because they couldn't prove that he, at that point, they couldn't tell he was the one that caused the accident or what the circumstances were, they charged him with driving while intoxicated with a child under 15. And then they also charged him with leaving the scene without aid. Both were felonies. They tried them together. He ended up getting, from the jury on I'm trying to make sure I get these distinguished properly, on the driving with the child under, they determined he was driving with a child passenger under 15 while intoxicated, even though they got him an hour later, and they didn't have, the evidence seemed sort of favorable, but juries, once they decide you're guilty, they don't even really need evidence at all. If they just look at you and decide you're guilty, that's really sad, but the jury gets to make that decision. And they decided that with almost no evidence that he was intoxicated, that he was. And they gave him 2 years TDC, and they ran it concurrent with the leaving the scene of a crime without helping, 5 years TDC. And so he got a total of 5 years TDC for both of those, tried at the same time concurrently. When you have two charges that are tried concurrently, the way the law reads is that your sentence will, when the two cases are tried together, then your sentences will run concurrent. Because he was in Harris County Jail for 14 months without being able to make bail or bond, or maybe they didn't give it to him because of the circumstances, that will apply toward his sentence. And because it was not an aggravated offense, either one of them, he will get 25% time. And so he will be eligible for parole at 25% of 5 years, which is about a year and a half. So he will feasibly be eligible for parole right now because his trial just ended. The problem with that, just so if anybody out there wants to know, is that you actually have to process through the TDC system, meaning that even if you were eligible for parole right when you got the sentence, TDC still has to come interview you and give you a TDC number because you're now a felon, and they need to determine whether you are eligible for parole. And so you may actually have to go to TDC and process through for 6 months, and you still have to go before the parole board, and they may deny your parole. They may make that person do the full 5 years. In this guy's circumstance, because there was a death involved, they may ask him to do it. But I don't know. He had no other priors. This guy had. It was kind of a sad situation because he said he didn't know. But anyway, so that's kind of how it works, and a little bit more information than you asked, but that's kind of how it works. So what is the actual textbook answer for driving with a passenger under 15 while intoxicated?
State jail felony and punishable by a fine not to exceed $10,000 with 180 days to 2 years in jail.
Okay, so that's why he got the 2 years, because that's a lower level offense actually than your third DWI. So if it's your first DWI and you have a kid with you, then anybody 15 or under, which that's kind of, I mean, you're really pushing the limit there. Yeah. Is it 15 or under, or it says under 15?
Under 15.
So if you have somebody that's getting ready to turn 15 the next month, and you are, let's say 18, it's your girlfriend, you're going to get charged with that, and it's no longer just your first offense. It's going to be your, a Class B. You're now looking at 2 years with an up to, was it $10,000 fine?
Yes.
Okay, so all you 18-year-olds that have jailbait girlfriends that are almost 15, do not be driving while intoxicated with them because you're just looking for trouble and the police are looking for you. Okay, what's the next question?
Penalties for intoxication, assault, which is DWI causing serious injury.
Okay, and that's also the DWI intoxication assault. It might also include manslaughter was the next one. I don't know what that one is. I'm just going to kind of throw it out there because I haven't done one before that I can recall where someone actually got hurt. Let's go with it's a second degree felony, and those are punishable. I think it's up to 20. Second degrees are up to 20 years, I think, with a $10,000 fine. I can't remember. Tell me what it is.
It's a third degree felony.
Oh, it's a third degree.
And
okay.
Punishable by a fine not to exceed $10,000.
Okay.
Confinement in state pen 2 to 10 years.
Okay, so it's the same as your third plus DWI if you hurt somebody, and if the person in the car is hurt, that counts. I know that. So you need to be nudging the person next to you. You're not hurt.
You're fine.
It didn't happen because of me. This happened before. Okay. So third degree, that's going to be it's state jail? Yeah, state jail.
State pen. Penitentiary.
Oh, state penitentiary. Okay, so that's 2 to 10?
Yes.
2 to 10 and 10,000. So they're still pretty bad.
Yeah.
But not as bad as the one with.
Is it the third?
No, that's third degree. No. Which is worse? It sounds like they're all about the same.
The guy that you with the case.
Yeah, the 15.
That was like.
Yeah, that one was bad.
Yeah.
Okay. But so far we're not. We're still at third degree for all the ones we've talked about.
Yes.
Okay.
Or no. excuse me.
What's the worst one we've talked about so far? Can you get it over? It's 2 to 10 in the state pen
It looks
on
like,
all of them, right?
yes.
Okay, so we have equal degrees of badness. If you are, let's see, it's
like
third degree, driving with a kid under 15, or you hurt somebody. It's all pretty bad, but it's not as bad as this last one, right? The last one's probably a higher
I
one.
would say it was similar to the third degree, or
Yeah.
excuse me, third
Drinking,
DWI.
getting stopped more many times, over 3 times, 3 plus, or driving with somebody under 15, or getting in an, I guess, if somebody is hurt because of your drinking, those are all third degree felonies. Okay, what's the last one? I think that one might be a second degree.
So I guess I was thinking the DWI with child passenger, that would be like first, second, third, like it would just get worse as it
Yes,
goes
it's getting
and
worse and worse.
be worse than if you're by yourself. Intoxication, manslaughter.
I think that's got to be it's either a first or a second degree, and that's going to be up to 20 years. It's going to be 5 to 20. I can't remember. What is it?
It's second degree felony.
Okay, second degree.
I would expect this one to be a lot worse, but it's punishable by a fine not to exceed $10,000
Okay.
and confinement in state pen for 2 to 10 years.
Really? Okay, second degree. It's first degree that gets a lot worse. Okay. So, yeah, I would have thought it would have been a lot worse, too.
Yeah, I
But
was like,
they've upped the degree one, and it's still 2 to 10, up to $10,000 fine. Mm-hmm. That's weird. Yeah. Well, what's it? The third and second degree. There must be more to it.
But I guess that's considering it being the first one? The first,
I don't know. I mean,
first
I thought
offense?
third degree was second degree is 2 to 10. I thought third degree was yeah, that's felony of second degree. Felony of third degree is 2 to 10. I'm questioning the answers on this website because I thought second degree was higher. But if second degree is 2 to 10, up to $10,000 fine, I need to go back and review that. I don't have to look at what the punishment is unless I'm looking at a specific case. All right, what's your next one? 2 to 10. 2 to 10. This says.
Let's say what happens after a DWI arrest in Texas.
Oh, I don't know.
Well, that one's there's
a whole bunch of
lot
stuff
to
there.
that.
But if we're going to hit I'm just going to hit the finer points. After a DW arrest, okay, this means that you've already done, and I'm just going to throw this out there because if you've been arrested, there's a gray area here. At what point are you arrested? Because when you're arrested, you should be given your Miranda warnings. In law school, we learned that you're arrested when you're not free to go. You're under arrest when you're not free to go. If that means that you are out in front of the car and the police officer stopped you and they're not letting you go anywhere, you're not free to go, then you're arrested. But they argue successfully in DWI cases that the arrest, they're doing an investigation when they stop you, and they still haven't decided whether you're arrested or not. I see this in motion to suppress hearings all the time. He wasn't given his Miranda warnings before he did anything. Anything you say or do will be used against you. Fourth Amendment rights. But they always argue successfully, the prosecution and the officers, that no, they weren't under arrest when we pulled them over. We were just making a traffic stop, a non-arrestable offense, and then we were investigating. And so they weren't under arrest until they were actually not free to go. In fact, even when the handcuffs were on them, they weren't under arrest. Obviously, you're under arrest. But that's not what they say in court. So what were you going to say?
The difference between being arrested and being detained, I feel like it really confuses people.
It
in
does,
the moment,
and
because you're like, this feels like
what
I'm being
you learn in
arrested.
law school.
I've never gone through it. But
Okay,
I was like, just putting that
tell
out
us
there.
more.
No, I used to watch
Dr. Collins. Are you listening? I know it's
Dad.
her. Yeah.
Doing the radio.
But yes, it's a gray area, and the thing is that you learn in law school, and they drill into your head that when you are under arrest if you are not free to go. But they always say, oh, no, it was just an investigatory stop. Mm-hmm. And then they go on to do the field sobriety test and get your blood alcohol and stuff. No, this is very important for our listeners, and I said this over and over again, and I'm going to tell everybody again, that try to have enough faculties with you that when you're pulled over, first off, when that siren goes off and you're pulled over on the freeway, you still use your blinkers and you still follow all the law, because even if you're being pulled over and you're trying to get out of everybody's way because you think maybe he's not even after me, that will be used against you if you're not still driving within your lane properly and safely using your blinker to get off the freeway and doing everything within your power to follow the law. Because even if you're only doing it because you're panicked because the police are stopping you, they'll still say that was the reason for the stop. Okay, if there's no reason for the stop, you'll win your motion to suppress. If they don't even have a reason, you're just driving down the road and the police pull you over. All right, that's the first thing. Once you're pulled over and you're not free to go, and particularly in your DWI, do not believe you're not under arrest. I mean, don't believe because you're under arrest you need Miranda warnings and I want my attorney. Yes, ask for your attorney, but also remain silent. Just because they haven't given you your Miranda rights, that you have the right to remain silent, you better remain silent because they're going to say you weren't under arrest, and anything you say at that point can and will be held against you, and they don't even have to tell you that. So when you're pulled over for your DWI and you're not under arrest yet, even though you technically can't go anywhere, don't say anything. You are by law required to show your ID, your driver's license, and if they ask for your insurance, you should show them the insurance too. So that's not a reason for your arrest because that's a crime. So show them your registration. They always say right in your glove box, have it handy, and don't make a lot of fervent, quick moves because they'll think you have a gun, and then you know where that goes. So have in your glove box your insurance that's up to date, your driver's license close by. If it's not close by, just slowly get it. Your registration and registration, insurance, license. I think that's all you really need. If I always turn my phone on record and put it down beside me, just to make sure that it's clear what's going on in case I don't even have a real cop beside me and it's late at night. So and because they don't like to be recorded. Police officers get really antsy if they think you're being a smart aleck and recording them. So have your phone in a position where even if you can't get the video, you have a voice recording going. Short of that, if you're talking to somebody, ask them to stay on the line and have them record it, or they can be your witness. There's as nice as 95% of the police officers are really nice. There's the 5% who aren't, and then there's the other people that aren't even in the percentage that aren't even real police officers, and there should be a fear right there for you. So always record it for your own safety. Then after you give them your registration, if they ask you to step out of the car, although you shouldn't have to step out of the car, you need to follow their instructions. If you tell them no, they're going to say that you were not being cooperative, and maybe they just want to see, how you're sitting. If you're drunk out of your mind, you definitely don't want to get out of the car. But you want to, that reminds me of a joke I heard where the police officer said, the question was, have you, something, the way he asked it, he's like, and I wish I could remember the joke. It was something like, it wasn't, have you been drinking? It was, did you know it was, do you think that it's okay? He said, do you think it's okay to drive intoxicated in Texas? And the person in the car said, oh, well, I'm so glad you asked. I hope you don't. I mean, it was something really dumb, but there's smart alecks out there, and they make up really funny videos that you get to see in all your legal CLE classes. But what I'm getting at is very important. Just give them the bare minimum. Do not answer any questions. You don't have to answer any questions. You legally only have to give your ID. You legally don't have to get out of the car. You don't have to do the field sobriety test. You don't have to blow into the intoxilizer. You don't have to do anything, but when you're stopped, give your ID. That's it. Because if you're really, really drunk, you don't want to get out of the car. They don't know because you're not answering any questions, they don't know if you've got a sleeping disorder, if you're just sleepy. They don't know anything. But if you start giving them information, it's going to be held against you. And they've got their body cams going all the time. And they conveniently lose it when it's not helpful to them. The video gets lost. But so you're recording this. But don't, if they ask you to get out, it can't hurt if you're not drunk. And certainly do the blow test if you're not drunk because you won't get your license suspended. In Texas, when you get your driver's license, you're automatically consenting to do a breathalyzer test at your car. At that point, or you're going to lose your license. If you've been drinking, still don't do it. Still don't give them the breath test. Go to jail for a few hours or overnight because they won't have any evidence to convict you criminally, and you'll get your license back. If you haven't been drinking at all, but if you've been drinking a little bit, it may have a false showing. So but you still don't want to say I've been drinking because you're just asking for trouble. If you've been drinking at all, you're coming back from a bar, you've had at least one drink, you've got alcohol in your breath, it's going to register in the breathalyzer, just say no, spend the night in jail, you'll get out on a PR bond, it'll be dismissed, it'll be a hassle, but that's why there's always a designated driver when you go out to eat, because if you do get stopped, and we're renowned for getting stopped right off of I-45 by all the restaurants and bars, then you will get, they're just waiting for you. They're just waiting for you to come out like you're a sitting duck. Just say no and get arrested for the night. If not, get a designated driver and you don't have to worry about it because they can do all the tests. Now, let's say you've been drinking and we're going back to the detention versus the arrest. Before they're going to do all these things to try to prove, and they're going to sweet talk you into, well, I don't want to arrest you if you're not drunk. Just all you got to do is talk to me. I don't want to do this. If they didn't want to arrest you, they would take your keys and throw them in the field and say, you know what? You need to go over there and have a cup of coffee, and then when you're sober, you'll find your keys. And then they'll leave, and then as fast as you can find your keys, you can go home. But they're really looking to arrest you. That's what they do. And there's a task force here in Montgomery County, and they get pat on the back and they get awards when they get so many DWIs. So, I've been in these cases. They say that there's not, but there is. I've talked to enough officers to know that there one does exist. And so you don't want to do the field sobriety test when they ask you to do it, even if you think you can pass it, because no one can pass it. Even if you walk the straight line, they'll still say you were wavering and you weren't. They'll still say if you don't touch your nose right, or if you say all of the names of the capitals of the states backwards and spell them correctly, they'll say that you didn't start at the right one. They'll just punish you to death. So it's better just to say nothing, because if they want to arrest you, they're going to arrest you. And if you haven't been drinking, you won't get arrested because you're going to pass the little blow test by the car. Short of that, they'll probably arrest you. So just say nothing and quit being their friend. Okay? Now, once you actually are arrested, then they need to read you your Miranda rights. Arrest means you're handcuffed and in the back of that car and you're driving toward the station. Okay? If you don't speak English, or don't speak English well, and they usually play a Spanish video recording of your Miranda rights. If they don't give you Miranda rights, though, and you know they didn't, then anything you say after that point cannot be used against you and will be suppressed. This comes in really handy when after they arrest you, they pat you down and you've got drugs in your pocket. Very common for some reason here in Montgomery County that people have packets of cocaine or ecstasy or some drug that's not prescribed to them in their pocket. I don't know why. They always say they're just ready for a party. I don't keep drugs in my pocket because I'm usually not driving around, late at night ready for a party. But that may be my age group.
Holding for a friend.
They've heard that too. Don't admit to it, because here's the deal. If they pat you down, they're patting you down looking for a weapon. If you volunteer that they can pat you down, then they're going to find the drugs you have on you or in your wallet. So don't volunteer anything. If they pat you down and they find drugs and they say, oh, I thought it was a weapon, that's going to be suppressed, because a little packet of a tablet of drugs or a packet of cocaine, which I don't know why everybody's got that, holding it for their friend. It may not even really be cocaine, but for some reason, it may be bought from a bad dealer, but whatever reason people have these, and it won't come in because you weren't arrested for that. But for some reason, my clients want to confess like they're in front of the priest to everything they've ever done, including what they've got on them. I have a gun in the car. I don't have a license. I've got drugs on me. And, I drank 5 beers. And, it's like,
we weren't even going to go there.
Yeah, it's like, thank you. And then it all shows up in court, and your defense attorney is appalled that he or she has represented you before, and you could not remember these things, even intoxicated. All right. So don't say anything. Don't volunteer anything. Everything is a polite no. My attorney said no. If you have the wherewithal to say no, my attorney won't let me, they'll know you're not drunk, or at least not so drunk that you didn't know to say that. Okay. Now, all that being said, now you're arrested, and what happens after the arrest? I can only tell you that these are the few things I know because I've never been arrested that happen after an arrest. You're arrested. You should be read they give you a search incident to the arrest because they can. If you're, and there's another little caveat, if you were pulled over and you don't want your car towed, then you should ask the police officer to have someone get your car for you, because they cannot search your car incident to the arrest if you have a designated driver who within the 15 minutes of the time that you're pulled over can drive over there and get your car. Your car's not under arrest. You are. So get somebody so they don't tow your car and put it in the storage lot. You don't have to pay the tow fee. Don't have to pay the storage lot fee. You want to call somebody close at hand that has a driver's license and won't also get arrested to get that car. It's very favorable to you if you're carrying drugs in your car, if you get somebody to get that car out of the reach of the police and you don't consent to a search of your car. Why? Because they can't charge you with all of the the contraband in there, which happens a lot with my clients for some reason. They're carrying a lot of contraband. And so I've gotten a very, very serious motion to suppress granted where there's a lot of drugs in the car. The guy was obviously a dealer because he had a designated driver come get the car. They said we searched the car incident to an arrest. We have the right to search. Wrong. State law says that if there's a designated driver there, you do not get to inventory the car instant to arrest if you don't have to. The inventory is simply for the purpose of inventory what was in it before they take it and impound it. So call somebody. And but after they arrest you and you've got somebody that picked your car up, they read your Miranda rights. They'll take you to the station. They'll do the real intoxilizer. They'll do the real blood test. If you've said no to everything, you can't take my blood, I'm not going to talk. If it's on the weekend, only on the weekend, not during the week, the police in Montgomery County can get a blood warrant. And even if you say no, they can go get the judge that's watching his murder mysteries at home to zoom over a blood warrant. He signs off on it if they've got the right criteria, saying yes, you can pull their blood without their permission. Then they'll go get a phlebotomist. Usually they're available. They know where to take them now. They've run through this before. You try to get around it as an attorney, but usually they do it right. They'll get a phlebotomist or whatever they're called to take your blood, and then they'll draw it without your permission. If you give permission, then of course they'll do a breathalyzer or blood. You can give permission only for the blood. You can give permission only for the needle, the one that the actual blood and not the breath alcohol test. The problem you run into is if you say no and you're drunk and they get a blood warrant, you're no longer going to qualify for the pretrial intervention because you weren't cooperative. So you got to weigh all these things. And it's really hard to do when you're intoxicated. But I say just say no all the way along anyway and just take your chances, because it's better just to say no and they get the blood warrant and then try to find some other reason why you can get it, dismissed, right?
And then hire you.
Yeah, and hire me. I still say no, but if you just kind of, hopefully you're not making the decision, I'm going to drive drunk all the time, and you don't have to think about this in advance. But after you're arrested, they're going to get your blood if it's a weekend. But the really informative thing to know in Montgomery County is if you're drinking and driving and you say no to any test during the week, that's Sunday through Thursday during the week, not Monday through Friday, because Friday's like a weekend. They cannot get a blood warrant because I was in court.
Not on Sundays?
On Sunday nights they can, because that's considered starting the work week. But don't even take those chances.
Yeah.
But for sure, Monday, Tuesday, Wednesday, Thursday. Mm-hmm. Any of those, if you're pulled over in Montgomery County, and it's your first or second DWI, so it's a misdemeanor, they will not be able to get a blood warrant. So just say no to everything. They can't prove the case, right? Yeah. But over the weekends they can, because they're ready for it to get you, because there's a lot more people. And that's because the judges don't want to be bothered. They're sleeping. They're bugged all the time for things that don't matter, right? They're misdemeanor cases. Go away. Leave me alone. And so after they do or don't get your blood, then after that, then you'll go in jail and they'll give you your phone call and you try to get a PR bond. And if you've got a lot of felony cases and your bond's really high, you want to wait until you can contact an attorney to fight for a lower bond rather than just go pay it. You don't want to pay a bond company if it's a high bond, or if it's a low bond, you don't want to pay a bond company, because if you have the cash, just go pay the jail. You get it all back. If it's a high bond and you don't have the cash, you've got to get a bonding company. Low bond, pay cash, all to the jail. You get the whole amount back. If it's a low bond and if it's a high bond and you don't have the money to get out, you've got to pay a bond company. Mm-hmm. The reason I say go to the jail and just pay it is bonding company, you'll never get your money back from them, ever. Mm-hmm. It's gone. You see you later. That 10% of your $30,000, $5,000, whatever, it's gone. But if you can pay it outright, they'll get all the money back that you put in. So it was just a mistake. All right. First DWI, make the mistake. If you don't get a PR bond, pay the bond to the jail, and get out of there and go home and tell your significant other or whoever, that you're sorry you got stopped, and then y'all can have a drink over it at home where you're not going to be in trouble and you're not on bond, or whatever. If you're on bond for something else, don't have to drink about it. Okay, all of that. What did I miss after the arrest?
Oh, well, how do I shorten this? Should I just read the
Just read the first sentence on each one, because I have no idea.
Number 1.
5 minutes. Thank you. We're getting the 5-minute warning. Wow, we didn't get the gun laws.
Number 1, administrative license revocation. To preserve your right to drive in Texas, you must request a hearing within 15 days of when you were served with a notice of suspension, usually the date of arrest.
Right, you get it when you're arrested. So that was what we talked about earlier. Mm-hmm.
And so number 2, first appearance. If you have been arrested and released for a misdemeanor DWI, you will be given a date to return to court, usually 30 days after your arrest.
Right, and in Montgomery County, that first arraignment, if you have an attorney, you don't have to show up for it. Your attorney does it for you.
Number 3, pretrial conference. Your attorney will discuss your case with the county attorney to discuss the best possible resolution of your case.
And that full month before, when you didn't have to show up, your attorney has filled out all the paperwork to get the discovery that they have, whether it be the blood alcohol level, the offense report. That's why they're ready to discuss it with you and with the prosecutor, because they've now looked at the evidence.
Number 4, suppression hearing. The court may suppress some or all of the evidence against you if your constitutional rights have been violated.
Right. It's usually the Miranda right, or they've searched your car without permission, all the different constitutional things that they shouldn't have done. You can move to suppress, and then they have to drop the case because they don't have any evidence because it's all been suppressed.
And that occurs anywhere 6 weeks to 3 months after pretrial
Yes,
conference.
or any time before the actual trial. You can actually do it at trial.
Oh.
Mm-hmm. You have to pick the jury. I did a motion to suppress after picking a jury on a felony case once because they would not let go of it. And then I won it. It was the craziest thing, and then I won it. Mm-hmm.
Well, which number 5 is trial. You may either request a bench trial wherein the court hears the case, or a jury trial wherein a jury of your peers hears the case.
And that's really, it depends on the court you're in, because you may have a very democratic, very liberal judge that has a background of being an alcoholic, does happen to get elected or something, I don't know, and you want to go with them because you know how they rule. But if you have a really good defendant who's cute, Pollyanna, a big degree, people very likable, you definitely want to go before a jury. If you've got some tattooed out, a heavy guy that's a wife beater, you don't want to go to a jury. They're going to hate you the minute you walk in the door, and they've already sized you up without looking at the evidence. So that's how that works. Now, since we only have about 3 more minutes, I want to ask Courtney, what questions do you have over what we've gone over today, or anything you want to add about your own life experiences, or because you were a bartender for a while, right?
Yeah, I bartended for 3 years, so I've seen a range of intoxication
people telling you their stories.
Levels. Yeah,
I got arrested last week.
Yeah, like a lot of taking a lot of keys behind the bar.
Oh, good. I love that.
And always put it up top.
Dram shop.
But
Yeah,
yes,
that's perfect. Mm-hmm.
Much.
How did you know to do that?
Just had a lot of friends, or knew a lot of people that wreck, arrested.
So you just knew by their demeanor they didn't have any business.
Yeah.
Did the people you work for tell you that, or was it just something you knew?
It was, I felt like it was common sense, but that's not always the case with everyone.
That's
that
true.
Thinks that way.
That's so true. Mm-hmm.
Yeah.
Anything else you can remember or want to throw in there or
now
ask?
Put on the spot.
Yeah, it's rough. We're getting I've got to wind it up. So you off the hook. Saved by the wind up. Okay, well, you've been listening to the Legal Connection Show. You can listen to us live on Tuesdays at noon. You can also listen to a rebroadcast of this on by going to irlonestar.com. You can Google Legal Connection Show to get the YouTube. You can go to our Facebook, and you can listen to us on FM 104.5, FM 106.5. And most importantly, remember to serve God by serving others, and we will see you next week.